Seriously, my juices are about to flow. I think these are our main three protagonists that have affected what we as trust lawyers have been doing over the years. And I think that the estate and gift duties one was a real holdback and a floodgate for trusts. As I mentioned before, when estate and gift duty was in place before the early 1990s, farmers in particular were the vulnerable ones, because if your estate comprised assets more than $450,000, there was a 40% tax, and that usually meant selling off the farm and whatever. But the way that the legislation was phrased meant that you had to have your mirror trusts to try and deal with it. You all had mirror trusts to deal with, had those legacy issues. It's all well and good until someone dies, and then that's when the tears start, isn't it? Because all of a sudden access to the income's halved immediately, isn't it? And look, that's a whole different seminar day, how to deal with mirror trusts. But I think that this legislation has, if you track it, been responsible for a lot of proliferation of trusts in New Zealand. So there was a stopgap until '92. When it was zero rated, there was a bit more, actually we might add a little bit more here. And then when it was repealed, that's when the floodgates really opened, because you could then benefit from your own trust. And that's when we saw that proliferation of trusts, and it was dime a dozen people just churning them out for perhaps not always the best reasons. And it's interesting, we hear talk about capital gains tax coming in. That's always, some people are terrified there'll be a capital gains tax. They want to move their assets into a trust now before a tax comes in. I say, we've got no idea of that. And they're just absolute cynics. They would rather get it set up now because they can still benefit from the trust than take their chances. So tax is always going to be a motivating factor for some people. But of course it's the abolition of gift duty which has also changed things quite dramatically. And I presume everyone knows about that, yeah? And the only reason you would stick to your limited gifting these days is if you thought you wanted to qualify for a rest home subsidy. Now, I think there's an inherent problem with that, because if the chief executive of the ministry says, can exercise their discretion and say, I think that you've deprived yourself of assets deliberately to qualify for a subsidy, if you're gifting $13,500 per annum per person to qualify for a subsidy, absolutely you are depriving yourself of assets with a view to qualifying for a subsidy. And if we now set up trusts on the basis that really it's either for creditor protection or for asset preservation for future generations, if creditor protection is your motivation, how can it be that you would then have a gifting program of $13,500 per annum per person? Because that doesn't protect your assets. It's such a slow leak of equity across the trust, it doesn't make sense. And the only reason is you're trying to get a rest home subsidy. If you've got that much assets, just bite the bullet. You're going to have to pay for it. It's that's the way it is these days. And to see any suggestions otherwise these days is gee whiz, it's almost misleading advertising, isn't it? What mechanisms do you put in place to protect yourselves of people who are now gifting assets, $2 or $3 million at once, whatever, into a trust in one fell swoop? How do you cover yourselves to make sure that you're not subject to an argument of being complicit in somebody trying to shelter or hide their assets? Do you have a process for that? Because I know it's the Canadian system where the lawyers can be complicit for tax fraud in those sort of circumstances where you knowingly assist a client to shelter assets. What I do is I get a statement of position from the client saying these are my assets, these are my liabilities, so I can meet my costs as and when they fall due, and get them to sign that so that there's a representation to you that, okay, that all makes sense, you're solvent, you can meet your costs as and when they fall due. As at today's date, we're not sheltering assets, we're not hiding anything from anybody, therefore it should be okay. Because you can understand how easy it would be for somebody who was less than genuine to move $5 million worth of assets in one fell swoop across to a trust And then the question, well, what questions did you ask them to say that you weren't assisting them?
So also that country of terrorism.
AML-CFT? Yeah.
Extension's going to be a nice little gem, isn't it?
And that's, I guess that covers two aspects, and there's a next phase coming in with the CRS, and I think it's 1st of July. But the AML-CFT is, first part is obviously the identity. And if you tried opening a bank account with a bank recently, you'll know about that, where you've got to basically produce your firstborn and whatever and to prove you are who you are and your address. And then it's the source of funds. And that can sometimes be the sticky one. If somebody's transferring $5 million across to a trust, you say, where'd the money come from? Oh, I saved it. Show me your records. Show me where your savings came from. Oh, I can't. I say, well, how can I establish that you haven't got it from ill-gotten gains? And if that's the case, if you can't get past that first threshold, you need to think of a different way of trying to solve it. Or say, well, I can't help you because you can't pass the minimum threshold. And
that's what banks have to do.
And it's better these days to have one unhappy client saying, geez, these buggers wouldn't do what I said because I couldn't prove to them the source of the funds, rather than being hauled up before the courts in time to come. I had the fascinating experience when prostitution was decriminalised and Yellow Pages still existed. I had somebody contact me to come in to talk about a trust, and the fellow walked in with his partner, all dressed in black, and there were tattoos everywhere and piercings everywhere and whatever, and we had to sit down. I thought, I know what the score is here. We're beating around the bush for a while, and we eventually reached a stage where he said, now that prostitution has been decriminalised, I want to legitimise my business because there's only so much I can spend cash on these days. My car's got a $250,000 sound system, and what else can I do? So I thought, he said, if I can incorporate a company and run it through a company and then have trusts and things and I'll pay my tax, it'll all be sweet. And I said, that's fine, but first of all, you go and see an accountant and get your tax all sorted out, and when that's all nice and clear and you're all up to date, then we can have a chat. And so nothing happened, and he said, oh, well, how do I pay you? And he unzipped his little fanny bag, and there was a big fat wad of notes, and I said, we'll send you an invoice. That was a complimentary discussion. We'll send you an invoice if we do any work for you in due course. And it was a while later that he ended up killing a policeman in a drug raid. And I got the letter from the police asking for my files and records and things, and fortunately they were all pretty nondescript because nothing had happened. But yeah, just interesting, the question, well, where did you get your money from? I know where the money is coming from, but you've got to make sure it's clean before I can deal with you. I don't want to be put in that situation. And I didn't feel too bad about that. And when the police letter came through later, I felt even better. So it's sometimes making those hard decisions. So Estate and Gift Duties Act, it's freed up a lot of what we do, but there are issues to think about, and they can't be underestimated. Income tax, that affects everything we do, a bit like the PRA. Its tentacles go everywhere. And if you're like me, you won't be a tax lawyer. And you'll know a little bit to say when the bells are ringing or the flags start waving, you say you need to go and get your advice. And that's in particular going to happen where perhaps clients are looking to transfer shareholdings in their privately owned companies across to a trust. Imputation credits, continuity rules, losses, those sorts of things. I know enough to be dangerous, and I know when to say go and see a lawyer, or this is my reporting letter, copy it to your accountant, gets me tax advice. But Income Tax Act affect the setting up of the trust, the transfer of assets to the trust. It might be that because of continuity rules, you can only transfer a certain number of shares each year to the trust. GST implications, depreciation clawback used to be an issue where people were transferring investment properties to trusts. It's a question of being aware of the issues, but really not giving the advice unless you are experienced and qualified to do so. Do your letters of engagement when you're setting up trusts put in assumptions or qualifications saying that you're not qualified to give tax advice or you don't give tax advice? Yeah, and we don't give investment advice. We recommend you seek your own tax and accounting advice and your own investment advice. It's amazing what people will suggest after the fact. And one of the things I guess that's worse for us is if we just start on a process of transferring assets to a trust and that triggers a tax incidence. Depreciation clawback was an ugly one where there might be a lot of money to be paid back, which although it just affects cash flow, if a client thinks they're paying a few grand for your trust structure and then get a 25 grand tax bill, they're not going to be happy if they don't expect it. So again, it's being aware of those sorts of issues and getting the advice signed off by somebody else. And then there's our old favourite, the Property Relationships Act. It covers everything we do. Can't escape it. Insidious little creature. But we as trust lawyers know that. It's our brethren who are general practitioners or property lawyers or commercial lawyers who don't sometimes understand the nuances. Doing company buyouts or purchases in the sole spouse's name or things like that, and the issues that can give rise to. There'll be, even for property people, property lawyers, where there might be a husband and wife, and I use husband and wife because invariably that's the sort of situation that arises where the husband is making the money and they want to buy an investment property so that husband owns it entirely in his name so that he gets full tax deductions on the interest payable for the loan. And then the relationship breaks up and all of a sudden you've got an asset in one spouse's whole name that was transferred during the marriage, and the other one, we know what the result will be, but there are questions asked, why did you do that? Didn't you realise? What mechanisms do you put in place for it? Or can you produce a letter saying to your client, you need to be aware that whilst we've structured it this way in accordance with your instructions to achieve maximum tax efficiency, you need to be aware that if the relationship fails, your wife or partner or whatever will have an inchoate right to one half of the property. Lay down was there, no questions asked. And that can be bold, highlighted, whatever, to protect yourself. But they're the sort of things we need to keep telling our clients with various circumstances. And property relationships these days, transferring a family home to a trust. Clients normally think, often they own it as joint tenants and they transfer it across. But if you drill down, sometimes you'll find where one client may have inherited more money, and it's always been regarded that the money they put into the house will be theirs. How do you deal with that one? And you need to ask the client if that's a question. You've probably left your run too late if you haven't got it documented, done it by way of loan or a contracting out agreement, but you don't want to make sure you're compounding issues. You want to ask your clients, we will presume that you own assets equally unless you advise us to the contrary, or something like that, to protect yourself, to make sure that we're aware of the impact of some of this legislation, because it can just be so ugly. And we're the ones who get blamed at first instance, because we're the lawyers, we've got the insurance and all that sort of stuff. Just go for the lawyer. It's the easiest call, and it's really disturbing. You try and do your best for clients and they turn on you. It's ugly. So if they're our legislative influences, there's another, okay, I can just tick off that's a technical aspect done. That's good. Let's get into some nitty-gritty basic trust law. Remember this, the 3 certainties? There's actually suggestions there are now 4 certainties. If they're the 3 certainties, what do you think the 4th might be? The answer is capacity. There are now suggestions that you've got to have the capacity to do this to be a valid trust. And given given the litigation that's going on and all the correspondence you'll see of disputes and things, you can see it's becoming quite a real issue. So although it's not a technical requirement for the certainties, I think it's becoming a practical requirement for certainty that the party settling the trust has capacity to do so. So you'd make that number 1, wouldn't you? Have they got the capacity? And that brings back the question, how old does a person need to be before you have to start questioning their capacity? If it's a new client, how do you establish capacity? What do? Do you have a discussion with them? Is that enough? I think it was, again, Green and Green, where there was talk that Mr. Green, there were questions of his capacity, and that whilst the family who saw him regularly saw that he was tired and ailing and suffering from his his illness and worn out and sometimes couldn't remember things. When people were coming to see him, he could get himself spruced up and dressed and focused, and they would think he was fine. So have we got the problem that when clients come to see us dressed in their Sunday best, that they're focused, they're on form, and they are, we think, actually, I've got no reason to doubt them. They look to have capacity to me. But we don't see them regularly. If they're brought in by a child, there's a real problem there because the red flags are waving immediately. There are issues there. But a new client on their own, how do we know? If it's a husband and wife, for example, one of them might be supporting the other, and one of them, you often find in discussions, one of them is more dominant than the other. Is the less dominant one aware of what's going on? Have they got the capacity to understand? It might not just be capacity. Are they just suppressed and don't understand what's going on? Now that's, I guess, one of the reasons why when you're meeting with clients to set up trust structures for a couple, you can't just take the instructions from one spouse. You need to see them both and discuss it to get an inference as to what's happening and to see the interaction. Have you ever set up a trust structure and signed up with your clients and thought, there's no way this relationship's going to last? Because you can tell from your experience there are issues. It's sad. You think, why are we doing this? But yeah, I've had that on a few occasions. You think this isn't going to last.
The argument at the table that just erupts, fixes the conversation.
You can do. You think, yeah, take a step back, have another glass of wine. And you can see it, and it's sad. But and then you go back and you do your double check to make sure everything's safe and whatever.
Where you've actually asked all the questions and the person, this is in particular to will instructions, but it can relate to the set law as well. You've asked them the types of questions where you can see that they can manipulate information, they know about their assets, they know what they're doing, they're everything's, as far as you as a lawyer and a non-medical person are concerned, they've got capacity to tell you and give you those instructions. And then it's queried later by the medical people who say, well, they actually didn't because they didn't meet the medical requirement. But that's what I'm saying. There's this real tension of what you're supposed to know.
That's a really good point. Does that mean that as lawyers we should be asking clients, are you on any medication that might affect your decision-making process? Are you on happy pills, sad pills, uppers, downers, whatever? Do you have an infection? Are you on antibiotics? Those sorts of things, to establish, on a layman's perspective, whether there might be medical issues that prevail. Have you had a serious accident lately? Have you been concussed? It's all a bit touchy-feely, but...
to me that's just not,
that's not what we do.
Yeah, and that's, even to enter that phrase, it's
So, to me, our test, and if you look at the test for capacity for a testator or for wills, it's Banks and Goodfellow. It's those four tests, isn't it? And if we apply that test, because that's quite a stringent test, if we apply that test to trusts, surely we're going to be in a strong enough position to say, in my view, at the time we discussed these issues, to me, they demonstrated no incapacity, they understood what they were doing. That's probably as far as we can go, because I think you're right. If we start to ask about, if we say, oh yes, I'm on these pills, then you think, okay, what do those pills mean? I'm not a doctor, I'm not a pharmacist. How the hell do I work out what that means? You fell off your bike last year and had concussion. What does that mean? What do I have to do now? Do I have to go and check with a specialist to say you've got the all clear? It's an area that we're not experienced in. So I think we need to go through I think the Banks and Goodfellow is a good basis for establishing where we go. And anything further, it's difficult. And all we can do is the best we can do in the circumstances. If somebody challenges it later, it's the balance of probability that rests on the proponent, the person trying to argue the incapacity or something. And then the questions will be asked of us. Okay, well, why didn't you ask Mum if she'd been to the doctor for the last few years and had been taking pills and things? And that's where it gets difficult, because the courts will say, well, that's a fair enough question. You're doing an asset plan for these people and putting in place a structure that will last them for 3 generations. Why didn't you ask what their medical history was? How do you balance that? Or do we have to say for every client, you need to get us a medical certificate to say that you are competent to do these things? Or do we say, is there anything in your medical background that we need to know about, and as a result of which you need to get a medical certificate to show you've got capacity? Is that the easier question, that you put them on notice and ask them the question, and say if there is something, okay, we need a medical certificate, even though you're 35.
Yeah, but then they go, oh, I'm on this drug and this drug. What's the next question? Are we supposed to know what the drug interactions are and how this drug would affect that drug?
I think it's a slippery slope, but again, the cynic in me comes back, and when it goes to litigation, and you've got the High Court up there sitting back on their benches saying, well, it wouldn't have been hard to ask them what their medical history was, and you'd say, but Your Honour, I'm not a doctor, I wouldn't know. Well, if that's the case, you could have got a medical certificate.
But if they seem, perfectly well, and okay, and they've, that Banks and Goodfellow test, they've basically, you've run kind of through that in your mind, and they've done all those things, then how much further should you go? That's what makes it.
Does it make that our standard interview process is to say, okay, just to cover off, we need to make sure that you've got capacity. We're doing these are the things we're going to ask. We've got to ask you and find out. I'll be up front that we're putting you through a test right now to establish if you've got mental capacity to do these things. Is there any reason that you are aware of that would affect your capacity that we need to think about, that could compromise your trust if it's being challenged in due course, and put it to the client?
Yeah.
And if they say, well, I don't know, but I'm taking these pills, I'll say, okay, if that's the case, let's just get a medical certificate from your doctor just to make sure it's completely clear. And maybe that's part of the evolution of practice that we have to go through, because it makes me nervous what judges impose upon us in retrospect, and we're the ones who become the ones to blame because we're controlling the process. And it puts us, I think, in an invidious situation. But we have to keep thinking, what can we do to minimise the risk and to make sure this structure is as robust as possible? And it's pretty embarrassing at times to say to clients, well, I know you're 35, but because you've said you've been concussed, I think we need to get a medical certificate to make sure it's all okay.
And a lot of them would actually be quite offended and get quite angry with you, I would think.
Yeah. And then I guess it'll be a question saying, okay, well, look, this is my advice to you, because these days this is the way things are going. And it might be horses of courses. If it's a blended family with adult children, you say, okay, look, we're in a situation where there is an inherent risk already. If we want to minimise the risk of the integrity of this structure being challenged, perhaps what we should do is we should get a medical certificate, because you're 65 and or whatever. You can't be ageist, you can't be sexist, whatever. But if there is an issue, perhaps we're better off to deal with it and put it to bed. It's your call, but I'll be noting it either way in my records that I've recommended it to you, and it's your call as to what you want to do. And perhaps that's the way of doing it. But I think we need to find a way of addressing it somehow. If capacity is coming into these certainties, we've got to address it. We can't put our head in the sand and say we can't do it because it's embarrassing or it won't work or we're not experienced. We've got to find a way of dealing with it somehow. Because I always think the rocking chair test, if you're up before the court, how do you answer the question, well, why didn't you get that checked out? Or why didn't you think to even ask the question? And I think that's part of the evolution of what we do these days. Because I know how litigators work. I know what they will throw out there. Well, you can't have been that good at understanding their circumstances if you didn't think about their medical background. Or perhaps you form an introductory letter when you send out the receipt of instructions that, when you send in the copies of your AML passport and your verification of address, please send a medical certificate to confirm there are no capacity issues. Make it just de rigueur. I don't know. I don't know what the answer is. I know it's an issue that we have to address, and we have to find a way of dealing with it as best we can. Because there is more and more involved with this. I know we've got a situation where there's an elderly woman who's got no children, and she set up a trust, and now the argument is, she didn't have capacity to understand what she was doing when she set up the trust, and it's a $30 or $40 million trust. And apparently her advisors have so far gone through about $300,000 or $400,000 of fees just to argue it all. Just basically saying that she didn't have capacity, even though now she's issuing authorities to uplift signed by her. It's an issue. So I think we need to bear in mind that capacity is a new issue and one to add there. But going back to the basics, setting up a trust, capacity, big one these days. What do you intend to do? And that'll be the question, like the Clayton and Clayton situation. What are you trying to achieve, Mr. Clayton? I want to have a trust that protects me from risk. What are your risks? What are the issues you're trying to achieve? I want to make sure that no creditors can get to me, or that if somebody chops off their fingers, I'm not going to be liable, or if I am liable, at least I've got no assets they can get to. Those sorts of questions. And then, is the trust the right thing for you? Are you pushing it too far that you want so many redactions and limitations and constraints in the trust deed you actually not trust anymore? It's perhaps more of an agency type agreement, or just a contract for services. What is it that you intend to do? And if you understand what the bare minimum requirements are for a trust, that helps you answer that question. But it's a question that has to be asked. When we get our property partner saying, I need a trust for this guy for a settlement tomorrow, they haven't been through this. They don't ask these questions. And that's the distinction of the service that we provide. There's a bit more expertise involved in making sure it's not just like putting in place a company. We've got a structure in place that makes perfectly good sense. Coming back to Banks and Goodfellow, what asset are you dealing with? Have you ever seen trusts where clients have come to your firm and said, I've got this trust. You say, that's good. How long has it been in place? 15 years. And what does it own? It owns the house. Oh, okay, cool. And you look for the records. It owns $10 because the house is still in their name. I've got a trust, but have you had transferred assets to it? Oh, no, but I've got a trust, so my house is okay. And then your question, or your statement before, clients come in and they've got no idea who owns what assets are trust assets or not. Fairly simple concepts. But and I think what you highlighted in that example I just gave is that there are people out there who just roll out trusts, sell trust as a commodity without giving the backup advice and service to make it work.
A lot of accountants used to do that. I don't know whether they're doing it now.
Some do.
But they used to just be off the shelf, standard trust from an accountant. My accountant set it up.
Yeah, and usually they were Russell McVeigh rip-offs. Sometimes they'd put the sticker over Russell McVeigh at the bottom. Sometimes they wouldn't. But you're right. And it's, I saw a client last week, and so their house is in trust, and yes, the house is in trust, but it was transferred pre-gift duty abolition days. I said, what about your gifting program? They said, what do you mean? I said, well, actually all you've done is just exchange your asset value at this stage. So if you're setting up your trust for asset protection purposes, the trust still owes you X million dollars. What have you achieved? And the jaw just dropped. And that's, they're simple issues, but simple because if you know what you're talking about, it's easy. So, what assets are you dealing with? Sometimes it gets confusing where there are multiple trusts involved, and the names are difficult to see because the trustees are all the same. You don't know which trust owns which. Some trusts will be income-producing trusts with tax numbers. All trusts should have tax numbers these days, but you can't tell which is which. And how do you know which trust relates to which asset? So, the certainty, what asset are you dealing with? And actually, this number 3, they're all big issues in modern practice these days. Who do you want ownership to pass to? Who are going to be the beneficiaries of the trust? And I think that can become a really big question if this Trusts Act, when eventually it comes in, and it requires mandatory disclosure to beneficiaries of the existence of the trust and all trust documents. There'll be plenty of people out there who don't want their children to know the trust exists.
It's a very common, we deal with a lot of people who just don't want.
Absolutely.
They've got vast assets and they do not want the children to be ruined by that.
Absolutely.
So they're one client particularly who said, I'm not going to make a trust because of they're aware of the sort of pending changes potentially, and it's a big mistake.
It's meant to make life easier for the layman, but giving those rights to beneficiaries is just asking for trouble. You'll see a huge raft of litigation arising, but I think that we trust lawyers will become quite busy in restructuring trust deeds, and I'd imagine that there'll be quite a few classes of contingent beneficiaries, which might specifically say that you have no rights in this trust unless and until X and Y have died, or something like that. And there might not be discretionary beneficiaries, there'll be some sort of contingent substitutionary beneficiary of some sort to try and deal with that, or they might just be taken out altogether, and it might be that the settlors will have a power under their will to appoint beneficiaries, that sort of thing. I think we will see some significant changes like that, and whilst that will cause some issues in the interim for tax planning, because there'll be a lot of parents out there who have trusts and have been allocating income to children to minimise tax, having built up their beneficiary accounts without realising that actually, oh gee, we've got to pay that child $500,000 because that's their asset. I think there'll be a number of issues around that as well. And then you have the issues of people who have no children and don't want to leave it to their, who do you want to leave it to? Oh, I don't know. Some people just be charities. Some people might be siblings, cousins, nephews, nieces, cousins, things like that. It's a question of working it through, because the last thing you want is to end up having what, in effect, a resulting trust where they set up a trust for themselves. And I think that's an issue. So I think we've... Oh, look, I've got fade in and fade out. My God, I'm clever sometimes. Look at that. So they're the technical wordings, aren't they? Certainty of objects and beneficiaries. So this obviously goes to some of the certainty objects. The settlor is desirous of making provision for the benefit of the persons and creating such trust as shall hereinafter appear. So prima facie, we've covered the certainty of intention. That's what we're planning to do, provided that the discussion with the client is consistent with that. But that's why that recital is there, isn't it? To state the obvious. Why is the next one there? The settlor has caused to be paid to the joint names of the trustees a sum of $20 to be held by the trustees, blah, blah, blah. Why is that there?
The trust can't be empty. There has to be an asset when it's created. That gives the certainty.
What creates the trust?
Subject.
What creates the trust? It's the transfer of property from the settlor to the trustee which creates the trust. So how many times do you see constitutes a trust, establishes a trust, creates a trust? It's the physical process of transferring assets to the trustees which creates the trust. The trust deed merely evidences the terms upon which the trust is to be governed. So it's completely wrong to say that a trust deed creates a trust. It evidences the terms of the trust. And so that statement, that recital B, is to meet that certainty of subject matter that, as you said, there's got to be an asset in the trust, but it's recording it's been paid. How do you satisfy that in practice? What do you do? Do you make your clients come in with the piggy bank and put $10 on the table, or $20, whatever it is? I do. So when I tell them to come in to sign, bring in your passport or your licence, copy of your address, so like original things so I can verify, plus $10, refer to recital B as to why you'll be bringing in the $10. Because they physically transfer the funds. And then of course you have the clients who forget to bring in their money. So they sign a trust deed, but the money hasn't changed hands. Have you got a trust at that stage? When does the trust begin? But it's a gift, isn't it?
Yep, right. In this case it's a gift.
Because if it's just a debt, it's a contract at that stage, it wouldn't be a trust. So would the answer be if they've forgotten to bring in their $10, an oral declaration? Because you don't need to have obviously a transfer of real property has to be in writing, but a declaration of trust for personal property can be oral. So do you then make a note saying, we hereby declare that we hold $10 on trust for the trustees, and you can put that in the mailbox, or what I'll do is I'll include that in my invoice to say funds advanced per oral declaration of trust, and do it that way. And that's why the initial settlement's always so low. If it's $100,000, you get some real problems. $100. How do you prove it's happened? $10, easier to deal with. But you get great kudos because you say to your client, now you bought the $10, bring it over, and you get the $10 out and you attach it to the trust deed or you put it in your pocket and say, well, there's morning tea done. And then, of course, I say, well, that must be a cheap cafe you're going to because I can't get morning tea for $10 anywhere. But it highlights in their mind the fact that there is a physical transfer of property. And I'll say, this is what has created the trust. And I'll say, you know, these are the basic aspects of the trust, that you are now transferring your money across to somebody else. It's not yours anymore, it's the trustees. And that helps to highlight the legal relationship of the trust. You know, if part of our job is to explain to clients generally what happens, that's part of the process.
But the settler is often the trustee.
One of the trustees.
One of the trustees, that pocket to that pocket?
Yeah, it could be. But if there's an independent trustee, as hopefully there will usually be, and they'll all be in the meeting at the same time, because the last thing you want is the three trustees that come in at separate times, because that's just so expensive that you have to write off time for explaining the trust deed to three people. But I would normally attach the $10 to the trust deed. Take a copy of it, so you've got serial notes and things like that, put it through your trust account as an advance to the trust, and then you can pull it back as a... I used to have it sitting there until I got the accounts team on my back saying small balances, you know, you've got 400 small balances of $10 each here, what do we do? I can't have them all, we can't put them on interest-bearing deposit because it's too expensive to do that. So then you have to do letters saying, you know, this was the advance on trust, so this is a partial repayment of debt or something like that. But I think it's, if we're going to the basics to make sure we have a robust structure, get the basics right, have a physical transfer of funds. If there's no money around, do an oral declaration of trust, which is in evidence by a one-page declaration of trust. I declare that I hold $10 on trust for the trustees of the such and such trust, evidenced by trust dated whatever date. Because we're trying to minimise the risk and to give as much integrity to the structure as we can. Does anybody else here collect the physical settlement from people? Anyone?
Not physically with a $10 note. But
How do you deal with it?
well, generally I get to pay it in, you know, like into the account or something like that.
Once they open it,
Yeah.
but
Right.
they've got to open the trust bank account.
Because I've had an interesting discussion before. If they transfer the funds, well, let's say they don't transfer the funds, but they settle the purchase 2 days later, and they've transferred money across to the trust to purchase, when does the perpetuity period start? If the trust is not created until the transfer of property, and the trust deed says the perpetuity period starts on the date of this deed, but your trust doesn't exist, do you have perpetuity period issues because it's potentially going to run for longer because it starts later? Or do you think, oh, what the hell, we'll just rely on the wait and see rule and see what happens? But technically, it could be an issue. Again, we're trying to minimise risk and to provide robust structures to make sure that we're not going to be in those technical issues. Because one day there'll be some smart litigator who says, actually, show me your transferred money and when the trust started. And the question is, when you subsequently transferred funds to a trust that didn't exist, was it just a bare trust? Can it be construed as being an accretion to that original trust because it didn't exist? You can sort of see the logic in that, can't you?
Yeah. Take the other way. Yes, it's $10, right? You need to create a bank account and put the $10 in. Okay, well, obviously we've got a trust created with no money, so we don't actually have a trust, but you're now applying for a IRD on a trust that doesn't exist, and now you're trying to create a bank account for a trust that doesn't exist.
Non-existent.
The whole thing fails all the way through.
So it seems like a really silly point, but if you really pull back the rings of the onion, you can think, actually, there could be some issues here.
It's a good point, because particularly now that you've got to get the whole process of forming the trust, getting the trust deed signed, then applying for the IRD, which you've got to send in the trust deed, and then transferring the property. It absolutely is an issue.
Yeah. And look, you can those issues with the IRD are honoured in the breach, aren't they? Because it's all presumption that it's all okay. But it's going to be when there's a challenge and there's litigation afoot and the question of the integrity, how strong is a trust? And the questions could be, actually, I think this is, for a creditor issue, I think this is just a bare trust because although you purported to form a trust on this date, It wasn't until 5 days later that you actually did so, and it's not, what trust did you create at that time? Was it just a bare trust by transferring funds to those trustees, or was it clear that it was subject to the terms of a non-existent trust that didn't exist, which said it would acquire more assets in time? I think there's room to argue that. I wouldn't want to, but I think that if there's enough money involved, you're acting for a creditor, multi-million dollars, and if it's a bare trust, obviously there's no help to them whatsoever. It becomes an open door for the creditor, doesn't it? Or a PRA type issue. So it's a basic principle we need to get right.
You're saying that you do with an oral declaration when you do?
I think an oral declaration was right because you don't have to have a physical transfer between parties. Oral declaration with the transfer.
By the lawyer?
Yeah. Well, no, the client would write down and say, I confirm I've transferred, I hold $10 in trust for the trustees of X Trust. Right. And so that will cover you, because it has to, because oral declarations work. But it's when there's no money involved and it doesn't change hands, or it's never received. How do you know? So, it all seems really simple, but if you look at the basics, sometimes there can be problems and issues. So let's move on a little bit. So we're analysing our trust deed. We sort of haven't got past the first page yet, but we know there are issues, and we've got to get the basics right. Next basic is the beneficiaries. Now this will be up for grabs, I think, once the if this new act comes in. But this is how I think that the classes of beneficiaries could fall in general practice. Final beneficiaries. To me, they are, you can call them any sorts of things. Final beneficiaries, residual beneficiaries, terminal beneficiaries. Basically, whoever stands to receive a share of the trust fund when the trust comes to an end. Discretionary beneficiaries are the ones who are eligible to benefit from the trust during its lifetime, and will probably include, in most cases, the final beneficiaries. So in this case, we probably have mum and dad as settlors. They will be included as discretionary beneficiaries, and the children of mum and dad will be the final beneficiaries. That's fairly standard stuff. Sometimes you might just have income beneficiaries, and this might be obviously for a trust created under a will. There might just be an income beneficiary, life tenant. You might just have capital beneficiaries. If you are introducing new partners to trust, how many times do we have people who say they set up a trust because they've been through a relationship breakdown, I want it tight as anything, I want no one else to come into it, and then a few years later they've met a new partner and they want that person to come in as the beneficiary of the trust. You say, hang on, remember when you broke up and you said you wanted it wrapped up as tight can be and then duct taped and nailed and whatever, and now you're saying you want me to take off the tape and open it up and bring in this new person? Oh yeah, because I really love her. You told me that, yeah, okay, that's fine. But if you break up, how happy would you be that this person is part of the trust? Oh, but we won't break up. I say, humour me. If it happened, because you've been through it once before, you've got form. If it happened again, how comfortable would you be? Are you not comfortable with the fact that while this person is with you, they will benefit vicariously from the trust through you? Anything that they want or need will come out. Because you're a beneficiary, you get the benefit. They say, yeah. And so are you happy that if you were to die, this person could then benefit from the trust? And, what if they met somebody else and had a new partner? And they're a beneficiary of the trust, and that person benefits vicariously through your partner, new partner or spouse. And then you think, yeah, okay, it starts to make sense. And so, with a bit of discussion, I can normally get the trust, either they say, no, we won't do it, good call, thanks for reminding me, that's why you're here, or no, I'm adamant this person is in, but I only want them to get income from the trust because I want them to be looked after. So they might just be income beneficiaries. Invariably, they will never be capital beneficiaries because they usually want it to go bloodline down. Invariably, they draw that line there. And then sometimes it's a hybrid with the contingent beneficiaries. This person is a beneficiary while they remain my spouse, and because if they lose capacity, there could be an issue, or my unmarried or unpartnered spouse or widow. And it might be that you have to do a clause in that regard, it would be unless and until the trustees are satisfied in their reasonable discretion that this person has entered into a new personal relationship. That's pretty dodgy, that one. I always feel uncomfortable with that, but sometimes a client will be insistent in its question saying, I can't give you a guarantee, this is the best I can do, but I can't guarantee this will work. But if that's what you want, it's your risk. And
Why do you think that's dodgy?
The more, I think it could be challenged, the question saying, did the trustees exercise their discretion reasonably? Everywhere you look, there's a little option either way, and it just opens up the doors for questions to be asked. I prefer to have much more certainty, and if it's going to be unless they, remarry or repartner, well, a conniving person will not have a new partner. They will have a friend or a companion, but they will not ever admit to being in a de facto relationship to which the Act applies, and therefore they still qualify. So I just think it's dodgy. And then substitutionary beneficiaries, that's the royal wipeout clause. If all the final and discretionary beneficiaries have gone, I include a gift over class, somebody else. Often it's going to be nieces, nephews, cousins, things like that. And then, of course, you've got your ultimate gift over of charities. So I've got some clients who don't want charities in there. I say, well, you realise if everybody wipes out, it goes to government, and then they bring in a charity. How do you guys structure your class of beneficiaries? Similar to that? Yes. Tell me about your class of final beneficiaries. No, I won't ask you to tell me about that. I'll tell you about the number of trust deeds I see where the settlors are included as the final beneficiaries is unbelievable. The settlors are included as final beneficiaries. So it might be the final beneficiaries are Mr. Settlor, Mrs. Settlor, and their 3 children. And then the final vesting provisions say that the trust fund is to be paid out to such of the final beneficiaries as the trustees decide, or if they don't decide, to the final beneficiaries equally. Either way, there's a resulting trust. Unbelievable. That's asking for trouble. You've got to distinguish your final from your discretionary. Well, I've seen some trustees where they just have a class of just beneficiaries, and during their life you can give capital and income to any of the beneficiaries, and it'll again be mum, dad, children, and on the vesting provisions the same again. They're not conscious of the fact of the resulting trust issues. And then, of course, if that's ever challenged, you bring it back to the Clayton philosophy. Well, you could exercise your discretion to bring the trust to an end earlier, and then just appoint the capital to each of the settlors, so a resulting trust. So how hard would it be, based on Clayton, for a court to say, resulting trust, invalid for these purposes, creditors, here's the money. To me, it's not rocket science. It's cynicism, but I don't think it's a long bow to draw. So to me, again, pictorial description here. Who are the final beneficiaries? They're the ones who stand at the very end and get the wherewithal, right? There's a winner in this game. It's the final beneficiaries. They're the ones who get what's left in the day, not the people who start this trust off in the first place. And then we have the discretionary beneficiaries. It used to be the Cecil B. DeMille cast of thousands, wasn't it? Before, in the mid-90s, the beneficiaries were the settlor's wife, spouse, ex-wife, ex-this, the ex-wife's partner, the ex-wife's children, millions of people, because we knew at the time, until the trustees exercised their discretion in their favour, they had nothing, they had no rights. Post-2002, we cut it right back, right? We no longer have the cast of thousands because, A, it has the risk of giving those beneficiaries rights that, in particular, under the new Trustee Act, if it comes in, will get them up to court pretty easily. And also, even without that, we know trustees are meant to consider all beneficiaries. It's pretty hard when you've got a cast of thousands. So what does this say? This is an example of a class of beneficiaries. I don't know if you can read that, but the beneficiaries mean the settlor and the child of the settlor. So obviously this is a sole settlor. This is not a couple. Although I do see lots of trust deeds where husband and wife are the settlors, but they call them the settlor singular. I would rather, and my preference is, have a trust that caters for a couple. Husband and wife are these settlors and whatever, and recognises the existence of that joint relationship. And if it's a trust deed that's being established by a single settlor, male or female, that it will be tailored to meet that person's circumstances. It will refer to he or she or whatever, just to make sure we're clear on what we're trying to achieve. But going back here, beneficiaries means the settlor, the child of the settlor, grandchildren, remote issue, any other person for whom the settlor shall have natural love and affection and shall by deed appoint. That's... Yeah, these days, who do you have natural love and affection for? Does that include a wife or a husband? Do you have to have natural? You have to have natural love and affection for your children because that's just what happens. It's a bit broad.
It's contingent. They shall be appointed by deed. So, anybody claiming that.
But have you seen trust deeds where that part's missing and shall by deed appoint? Where they leave it open? Yeah, absolutely. Actually, I've got a pointer, haven't I? Oh, I thought I had a pointer. Ah, there it is. Yeah, and shall by deed appoint. I've seen that left off. Yeah, and so it's any other person for whom the settlor shall have natural love and affection. That's a bit dangerous because they've just rolled out a trust deed without thinking about it. The trustees of any trust of which any person specified in the above paragraphs of this definition are beneficiaries. That's a fairly general catch-all provision. But what I have seen are trust deeds where there's a definition of beneficiaries means any person who has an interest under this trust. Have you seen that? Good, bad or indifferent? Dangerous. Does that mean that somebody, a creditor claiming against a trust is a beneficiary? I could argue that. So I think, when we come to definitions, we've got to be careful. It's the old saying, you've all done a bit of banking and had to do solicitor certificates for the banks. And the saying has been, say what you mean and mean what you say when you give a solicitor certificate to the bank. Same thing here. Think about what you have to say. Beneficiaries, who are they? I put it as being the beneficiaries being either the discretionary, final or substitutionary beneficiaries. So it's enclosed with the trust deed. General provisions are going to cause problems. That one there, they put that last part in there to cover the certainty of object. You recall that the rule is you're meant to be able to ascertain at any time who the beneficiaries of a trust are. And in particular for adding in beneficiaries, are they a beneficiary? Having natural love and affection, there's sort of a statutory rule around who that would be. We know it's sort of family and whatever, although we don't know to what extent in the rules of separation of relationship, what they would be. But if I'm doing that, I actually don't use natural love and affection because I feel it's a bit broad. If I'm going to put in a restriction, I either say such other beneficiaries other than an ineligible beneficiary, and I'll specify who the ineligible beneficiary might be, so I know I've got absolute certainty of the class, it's everybody but that person. Or it might be such person who is related by blood, marriage or adoption within the fourth degree relationship or something like that. So we've got we can identify how far the family relationship goes. Because are you familiar with how those rules work for working at the class of relationship? Because parent to child is one step, and then parent to child to grandchild is 2 steps. But cousins, so if we were to have, it's not there, if we were to work out the degree of relationship between cousins, you don't just go, they're 1 step over. You go back up the line, you go cousin, up to their parent, up to their parent, and then because the cousin's parent will be a sibling of your parent, of the settlors, you're going to go up to the joint one, which is the grandparents, and then down 3 steps. So it's 1, 2, 3, 4, 5, it's about 8 steps, roughly. And
was the case of the Clayton, and I could be remembering it, correctly, but where it's I just can't remember the facts completely, but something about they came in on the fact that there's a relationship breakup. The husband said, or there was something in the trust that had been set up prior to this woman's marriage by her mother, and there was something in the trustee that said that something along the lines of my daughter and a spouse or something like that. I don't think the trustee actually said it. I think the outcome was that the trustee didn't say it, so he didn't get any rights. But if you left something in like that, wouldn't that open you up to somebody coming along who possibly might have been, if you haven't appointed them by deed, so it is contingent on that, but if you had left that off, wouldn't it open you up to somebody, like a son-in-law, for example, coming along going, well, I've got a right there.
Absolutely.
Yeah.
Absolutely. Which brings us back to the certainty of object, subject, exactly who are we going to benefit from this? Do you ever have, when I do the class of final beneficiaries, normally it'll be, the children of mum and dad. But you've got to be careful even with the way you draft that, haven't you? Because the children of John and Mary, or John and Mary's children, can you argue that if one of them dies and has other children, that those children are then classified as final beneficiaries?
We always draft ours, like children means children of the marriage of.
Right, yeah. So that's the certainty. I do this, I put final beneficiaries are the children of the marriage or relationship of X and Y, to make sure that we are very clear as to who we're locking this trust down for. So I think that's an appropriate way to do it. Somehow you've got to pull it back, otherwise there's uncertainty. But so many trustees, not enough thought is given to these issues, and when you point it out to a new client on a review, you say, did you realise that such and such could happen? And they go, oh, no. Oh, it doesn't matter, I'd want that to happen, or otherwise, or absolutely not, this is for this bloodline. So, we go back to those certainties. They're really important in how the rest of the trust deed follows on.
Well, we find it very unusual for a couple to sit at a table and agree to expand that particular one.
Absolutely, and 95% of the cases they do. I had one German couple who were quite comfortable that the survivor could exercise the power of appointment of new beneficiaries because they wanted the survivor to be happy, and whatever they wanted to do, that's fine by them. As long as during their lifetime together the trust served the purpose and protected assets for them, that's fine. Others aren't normally as benevolent as that. Usually it's sort of like, there's no way I want somebody else getting into these assets because this is for us while we're alive and then our children, our bloodline. I think we'll finish in about 10 minutes for some lunch, shall we? But we're just talking about beneficiaries. Who should have the power to add beneficiaries? So if we go back, what does that clause say? The beneficiaries are such other person for whom the settlor shall have natural affection and shall by deed. So the settlors shall by deed appoint. So the settlors have the power to appoint beneficiaries. Sometimes you see it where the trustees have power to appoint beneficiaries. Thoughts? Trustees, settlors?
You get an issue where the settlors pass on and now you've got separate trustees there and they can do it. There's the risk that they might appoint somebody that the settlor never intended.
I agree entirely. And that's one of the questions I'll ask clients. Do you want the power to appoint new beneficiaries to be exercised only while you're both living and competent, or by the survivor of you? So if the husband loses capacity, gets dementia, and is off in a home for the next 30 years, I know about a situation like this, and the other spouse met somebody else, should that person be able to appoint the other person as a beneficiary? Most clients come back with the result that no, they only want the power to add beneficiaries to be exercisable while they're both living and competent. Because, and I say I'd agree with that, because if the underlying object of one of the objects of a trust is certainty of intention, what's the intention? The intention is to form a trust for the benefit of this bloodline of beneficiaries, you want to make sure that when you die, that is what will be achieved, as opposed to having other people coming in. And so ordinarily people are comfortable with that and say, yeah, I want it locked down for that bloodline, so the power to add beneficiaries can only be exercised by the two of us jointly while we're both living and competent, and not the survivor and not the trustees, because I think if you pass that power to the trustees, it becomes a fiduciary power, and then there are questions of the exercise of that power. That becomes a huge risk for trustees, I think, especially independent trustees. That's something I wouldn't want to take on.
It's a hard one, because it does, I mean, if the trustees are exercising under their fiduciary duties and also within the purpose for which the trust was set up, having that power to appoint and remove beneficiaries, there may be circumstances where it could be of utility in the future in the limited circumstances.
I think in that case, it's the power of adding beneficiaries that would go to the grave or whatever with the first set law, but the power to remove beneficiaries might then have to vest in the survivor, or failing that, then the trustees, because if some sort of regime came back like the old estate duty, where you couldn't benefit from your own trust, we'd need to whip people out and set up new trusts. So it would just apply to the appointment process, not to the removal process, for that very reason. So I'll go back to that question, where was it? Should there be such a power? Yes, I think there should be a power under the current climate of trust law to add beneficiaries, but who should have it? Well, my view, in the people setting up the trust, be it sole set law or joint set laws, it should be them. In my view, only exercisable when they're both sui juris. And how broad should it be? Again, that comes back to that question that really you should only be allowed, my view, to get the certainty of subject related by blood, marriage or adoption. But sometimes there'll be people who say, I want people outside the family to come in, and say, that's fine, that's part of the initial planning discussion, we need to cover that. But you also need to be aware that if we're appointing beneficiaries who aren't family members and therefore outside of that tax rule of natural love and affection, there is the risk that when you make a distribution to them, there may be some tax implications. But again, they wouldn't care about that because the recipient beneficiary will be getting something they wouldn't ordinarily have got. Even if it's 50% because the rest has gone on tax, they're still going to come out ahead. But it's a question of making sure people are aware of those potential implications. Why don't we call it quits for there before I move on to the next one? Let's have a break for, should we come back about just after 1 o'clock? Half past? Quarter two. I'm a man of people.